Hi everyone, this is Lou. This is part of my QCAT series of videos, and in this video I am going to clarify what is determined to be urgent and non-urgent when you are deciding on making a QCAT application. All right, because if you file it incorrectly, then you will delay your whole case. A lot of landlords get very confused about what is deemed as an urgent matter and what is deemed a non-urgent matter when it comes to making their application to QCAT. Now, this may sound like it should be procedural, but it is one of the biggest reasons that a lot of cases get delayed, because QCAT will not hear a case if the matter has been filed under the wrong category. So in this video, I'm going to clear this up for you. And I want you to reference section 415 and section 416 of the Residential Tenancies and Roomings Accommodations Act 2008. Under section 415, this relates to urgent applications. So there are 4 elements to this. This is for rent arrears and the tenants are not paying their rent. You've breached them and you've told them to leave and they haven't left. It is relating to anything that is a safety hazard on your investment property, i.e. maintenance. It relates to a tenant not allowing access, denial of access for repairs of these hazardous maintenance, or if you want to sell your property and they won't let the agent through, or your tenancy has ended and you've told them to leave and they haven't left. All right, so it deals with recovering your property. And it will affect the security and safety and the ongoing occupation of your investment. All right, all of these are deemed as urgent, and you can actually make the application directly to QCAT without having to go through the conciliation process. Now, for everything else, it is non-urgent and it is covered under section 416 of the Residential Tenancies and Roomings Accommodations Act, and it deals with disputes, compensation claims, it deals with bond disputes, and it deals with any damages on a property, and it deals with obviously claims over rent increases as well. You have to go through the RTA conciliation process, and before you put in QCAT application form in, you need a NURD, which is a Notice of Unresolved Dispute. So, as a summary, if your rent is in arrears, then you can go straight to QCAT after you have followed the notice to remedy breach and notice to leave. Only after the notice to leave has expired can you make an urgent application to QCAT to get your property back. So, I guess, in summary, before you do lodge your application, I want you to consider these following aspects. Does it affect the occupational safety of your property? All right, did you want the tenants out? All right, are you entitled to have your property back? Is your property now unsafe? Then the second thing is does it relate to the rent on your property? If it does, then these are urgent, and everything else is non-urgent. If this little video has clarified this particular issue for you, can you please like, follow and share? I am still in the process of building up enough followers so that I can actually go live and do live workshops that will deal with all property management aspects, and I will be referencing the Residential Tenancies and Roomings Accommodations Act because that's what I specialize in. And I look forward to seeing you in the next video.